Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone. So I've got a few things to catch you up on this month, things that have been going on over the last few weeks, including various interesting cases that I thought I'd run through. But first up, I really need to mention the long-awaited Economic Crime and Corporate Transparency Act, very nattily titled. So this has finally received royal assent right at the end of October. And it's going to introduce pretty wide-ranging reforms aimed at combating economic crime and preventing the abuse of corporate structures in the UK. But it's going to be some really significant changes for UK companies. So it's really one to watch out for and have on your radar. So the Act is now law. It has, like I say, it's had royal assent, but most of its provisions are not going to become effective until implementing legislation, secondary regulations has been passed, and also we've got the new system changes up and running at Companies House. So that means that some of the key central elements of the reforms, things that you might have heard of like identity verification, all of those are probably unlikely to be operative until I would say the end of next year, the end of 2024 at the earliest, maybe even pushing a bit longer. But then there are some things that are going to come in earlier, possibly even right at the beginning of next year, 2024. So there's loads of stuff in the Act. But for today, I'm just going to focus on some of the key changes that it's going to make to company law in the UK. And as a result, the practical implications for companies arising from those changes. So I've already mentioned what I think is probably going to be the most significant of the Act's reform. So that's and one that's been getting, I would say, a lot of sort of airtime and coverage, and that's the introduction of compulsory identity verification procedures, and that's going to apply to all new and existing company directors, what we call PSCs, so persons with significant control over companies, and then also anybody who files information at Companies House. So it's not going to be possible to incorporate a new company until its directors have been verified. And then post incorporation, new directors will have to verify before their appointment is notified to Companies House. And similarly, PSCs, those persons with significant control, they're also going to have to verify their identity and then maintain that verified status as long as they're registered at Companies House. So we're still waiting for secondary legislation here to clarify actually exactly how the whole process is going to work. But individuals will be able either to verify directly with Companies House, probably sort of via an app type thing, or you're going to be able to do that through what's called an ACSP, and that stands for an Authorised Corporate Service Provider. Now, to obtain ACSP status, intermediaries and agents will have to be authorised by Companies House themselves, and they also have to be registered with a supervisory body for anti-money laundering purposes. So things like law firms, accountancy firms, they're going to fall into this category if they choose to register as an ACSP. But it's only going to be ACSPs and verified individuals who will then be able to file documents at Companies House. So just introducing some kind of gatekeeper requirements there in order to then verify, if you like, the veracity and accuracy of the information that is then filed at Companies House. So there's going to be a transition period for existing companies to comply with the new verification requirements. And then failure to comply by the end of that period could result in criminal sanctions and civil penalties. So, like I say, this one I think has been attracting a lot of headlines, and we've already been getting a lot of inquiries from clients and companies about the requirements. So, the good news is the requirements aren't live yet. But it is great that people are starting to think about them and think about what they're going to have to do. But we need to see those secondary regulations and more guidance from Companies House so we understand how that's actually going to work in practice before we can all get fully up to speed with that. And like I say, the latest thinking is that it's probably going to be end of 2024 at the earliest. So some of the other new requirements coming in, some of them relate to registered office addresses. All companies you'll be familiar have to have a registered office address at Companies House. So now there's going to be an additional requirement that the registered office address has to be what's called an appropriate address. And that means that a document delivered to that address would be expected to come to the attention of a person acting on behalf of the company. So things like a PO box or an unstaffed address, that's not going to be sufficient to satisfy this particular test. And then in another new requirement, companies are also going to have to register and maintain an email address with Companies House. And again, that needs to be an email address where emails sent to it from the registrar of companies would be expected to come to the attention of the company. Those email addresses will just be held and used by Companies House. They're not going to be publicly available. So in terms of timing of those requirements, the latest thinking is that they're probably going to come into force in early 2024. But again, we're still waiting for exact confirmation there. Then in relation to company and business names, the Act increases the range of circumstances where use of a company name can be prohibited, and it gives the Secretary of State new powers to direct companies to change their names. And again, these are provisions that we think are going to come into force early in 2024. So a company's not going to be able to adopt a company name where the name could be used to facilitate crimes or where it suggests a non-existent connection with a foreign government or an international institution, or where it contains computer code. So there's already a list of sort of sensitive names that you can't use in a company name, or you can't use without sort of additional justification as to why you could use that name. But these are some additional restrictions that are going to come in. And once they're in, the Secretary of State is going to have a new power to be able to direct a company to change its name if the name falls into one of these prohibited categories. And if the company then doesn't make that change within 28 days, then the registrar can effectively do it. What it would do is remove the company's name from the register and replace it just with the company's company number. So then those are some sort of changes which, if you like, are increasing the administrative burden on companies. There is one that I can tell you about, which is going to be slightly streamlining admin for companies. And that's that the Act is going to abolish the requirement for companies to maintain their own registers of directors residential addresses, of secretaries, and of PSCs. So at the moment, companies have to file all of that information at Companies House. So there are effectively those registers maintained at Companies House, but then they also have to maintain their own internal version of each of those registers. So there's an element of duplication there. So by removing the requirement for companies to maintain their own registers, that's basically going to mean that the information just has to be filed and kept up to date at Companies House, and the general public will be able to rely on that central record. But all companies will have to maintain their own register of members or shareholders where companies have shares, and they won't have the option just to keep that information available on Companies House register. And to help companies comply with that requirement to maintain their own register of members, again, that's an existing requirement on companies, but it's being beefed up. Companies are going to be given new powers to ensure that their member information is kept up to date. So they'll be able to raise queries with members or potential members. So then there are various other things coming into force, things that are aimed at trying to reduce the misuse of companies. So that includes things like a requirement that all companies on incorporation are going to have to confirm that they're being formed for lawful purposes, and to confirm that future activities will be lawful on each confirmation statement. Again, we think that's going to be an early 2024 implementation date. There's also going to be a requirement for companies to record the full names of individual shareholders in their registers, and also to provide a one-off full shareholder list with their first confirmation statement following implementation. So once these provisions are in force, the next confirmation statement that a company files is going to have to contain a complete full list with all their shareholder information in it. We're also finally going to see the ban on corporate directors coming into force with some limited exceptions. So that's something that's been mooted since 2015, actually, but it is finally going to come into force. So if you're a company that currently has another company acting as a director, you need to think about that and how you're going to deal with that ban. And then another sort of issue that there has been previously relates to the fact that once information's been filed at Companies House and appears on the company's record, it can be very difficult to get that removed. Either because it's been inaccurately filed, or there's just an error in it, or maybe it's a fraudulent filing. So the registrar is going to have greater powers to query information so that filings that seem incorrect or inconsistent can be scrutinised, rejected, and in some cases even removed from the register once they've been filed. And that provision, again, is another one that we think is going to come into force in early 2024. So, like I say, we're still waiting for the sort of full implementation timetable for the Act. But I think it's a good opportunity now for companies to start reviewing their compliance, particularly with those provisions that the registrar has indicated are likely to come into force in early 2024. So, as I say, that includes things like ensuring that registered offices and email addresses are going to meet those new requirements, and that any existing or maybe a proposed company name isn't going to fall foul of the increased restrictions. And then I think, what else can you do to prepare? I think generally it would be a good idea to check that your filings at Companies House are generally up to date and accurate, because those new powers that are being granted to the registrar to scrutinise information on the register means that I think we're going to see them being much more proactive in the approach by Companies House in chasing up omissions or errors in filings. So becoming, like I say, much more of a gatekeeper of accurate information, rather than just a sort of passive repository of information, which perhaps is more what Companies House has been previously. So there's lots to look forward to there in 2024. And like I say, we'll have to just see what the timetable is, and obviously we'll keep you updated on that. So that's stuff that's coming up. Now let's have a quick look at some cases that we've had over the last few weeks, where they're quite interesting decisions. And first up, we've got one where the Court of Appeal has unanimously set aside a decision of the High Court holding that the repayment of an unsecured debt by Comet Group plc to a connected party 9 months before Comet entered administration was not a preference. So before we get into the facts, we need to understand what is a preference. So that's basically a type of reviewable transaction. So that's a transaction that can be set aside once a company is in liquidation or administration. And a company gives a preference to a creditor if it does anything which, if the company then goes into insolvent liquidation, results in that creditor being in a better position than they would have been in had the relevant thing, the preference, not been done. So in order to challenge it, the preference has to meet various specified criteria, including that the company must have been influenced by a desire to prefer the relevant person. And that desire must operate on the persons making the decision for the company. So usually that's going to be the directors. And it must be present, that desire to prefer, at the time that the operative decision to proceed with the relevant transaction is made. And any decision as to whether the company had that desire to prefer and at what point is going to be based on the facts of each particular case. But I think the judgment in this latest decision does give us some useful sort of general commentary on the issue. So that's what a preference is. And then in this particular case, the key issue was whether the repayment by Comet of an unsecured debt to its sister company did actually amount to a preference. So the owners of Comet had entered into a share sale agreement for the sale of Comet in November 2011. That's when the contract was entered into. That agreement confirmed that at completion, Comet would repay an intergroup debt that it owed to its sister company. Now, notably, Comet itself wasn't actually a party to the sale agreement, so it wasn't contractually bound by its terms. But a director of Comet had been involved in the sale negotiations. He was also the group general counsel, so he'd been involved in that sale. So, after the relevant conditions had been satisfied, the sale agreement was completed in February 2012 and new directors were appointed to Comet. Those new directors then resolved that Comet would repay the debt as proposed. But Comet subsequently went into administration and then liquidation. So, when this first came before the High Court, the court held that Comet's repayment of the intergroup debt did amount to avoidable preference. So the court found that the operative decision to give the preference was made in November 2011 by Comet's director, who'd been involved in the sale negotiations, and that the operative decision was influenced by a desire to prefer, to put that creditor, the sister company, in a better position. The director's decision was deemed to have been made on behalf of Comet, so that, if you like, by the time the new directors then resolved to repay the debt in February 2012, their hands were tied because they were just following through on an earlier decision that had already been made. So, as I say, the High Court said, yes, it is avoidable preference. But then the beneficiary of the debt repayment appealed the decision, and the Court of Appeal has allowed that appeal, overturning the High Court's decision, actually based on a different finding of facts rather than a disagreement about the law. So the Court of Appeal found that the operative decision to repay the intergroup debt had been taken by Comet's board in February 2012 when the sale completed, and not, as the High Court had found, by Comet's director in November 2011 when the sale agreement was signed. So there was no evidence, the Court of Appeal said, there was no evidence to support the inference that the director had made a decision on behalf of Comet, and even if he had, it couldn't amount to an operative decision as it was conditional on board approval then being attained. And although the agreement had provided a framework for the repayment of the debt, it wasn't actually until Comet's new board considered the payment at completion and passed the required authorising resolutions that the operative decision was made. So it was agreed between the parties that the decision by Comet's board to repay the debt in February 2012 was not influenced by a desire to prefer. So because that was the point, February 2012, at which the operative decision to repay had been made, then the repayment didn't constitute a preference under the Insolvency Act, and so it couldn't be unwound. So the Court of Appeal here has helpfully confirmed that it's the point at which a company makes its operative decision that's going to be relevant for determining whether it has a desire to prefer. And identifying that point in time is always going to be a fact-based assessment, but the court's comments, I think, particularly relating to conditional agreements, can prove useful. So the court confirmed that, subject to the nature of the particular condition, an operative decision could be a conditional one. So, for example, a decision to buy land subject to the grant of planning permission could be characterised as an operative conditional decision. But a decision to buy land subject to contract, well, that's not going to be an operative decision at all. A decision which is conditional on board approval or ratification or something like that isn't going to amount to an operative decision, because you're always going to need a further decision to make the operative decision in that circumstance. So if you say, well, this decision is conditional on board approval, actually it's that board approval that is the operative decision. Okay, so the next case is also one where the Court of Appeal reviewed a first instance decision, and again held that the trial judge had erred. This time it was all to do with the way the trial judge had interpreted a material adverse change warranty, or a MAC warranty. So the original decision was in June, when the High Court was considering a MAC, a material adverse change warranty, in a share purchase agreement. And that warranty said that since the 31st of December 2017, which was the date of the target's last accounts, there had been no material adverse change in the prospects of the target company. So the judge said, the trial judge at first instance said, that when you're assessing whether there's been a breach of that kind of warranty, what you had to do was compare a baseline figure, which was the expected or forecast level of the relevant metric at the time of the contract, with the actual figure at that time, in order to work out whether the difference between those two was in fact material, and therefore whether there had been a material adverse change. So the trial judge, used the target company's EBITDA as the relevant metric. And having compared a reasonable buyer's expectations of the likely EBITDA in 2018 with the actual EBITDA, the judge said, well, yes, there has indeed been a material adverse change. So the buyer's claim against the seller for breach of the MAC warranty succeeded at first instance. But the seller then appealed that decision, and as we saw in the last case, the Court of Appeal held that the judge at first instance, had been wrong again. The Court of Appeal wasn't terribly impressed, I don't think, with the judge. Basically, the Court of Appeal said, well, the judge had used the wrong metric, the judge had used the wrong dates, and the judge had compared two different things. So they hadn't done very well. So in relation to the metric, so remember, the MAC warranty here was concerned with the company's prospects, and the judge had equated prospects with EBITDA. But the court said, well, no, that's not right, actually. If you read the clause naturally, prospects means chances or opportunities for success in a much more general way. It wasn't limited to that specific EBITDA metric. So sort of to help justify their decision, the court said, well, if you look at the rest of the sale agreement, the court has used EBITDA as a term in other places, but they could have used EBITDA in that MAC warranty, but they didn't. They referred to the word prospects. So they must have had something else in mind, not EBITDA, because if they'd meant EBITDA, they would have said it. So the judge used the wrong metric. Then the Court of Appeal said, well, the judges used the wrong dates as well when comparing the relevant metric. So what the judge had done was compared the expected level of the relevant factor on the contract date with the actual level on the same contract date. But actually, what the MAC warranty required was an assessment of the expected metric as at the 31st of December 2017 with the actual one in October 2018 when the SPA was signed. And then finally, the Court of Appeal said the judges compared two different things here. The warranty required a comparison between the company's prospects as at 31st December 2017 with its prospects, the same thing, as at October 2018. And not what the trial judge had done, a comparison of a buyer's reasonable expectations and the actual measurement. So the MAC warranty wasn't concerned with the company's prospects, with what the company's prospects in fact were at two different dates and not with what a buyer would have expected them to be. So as a result, because of all of that, the court allowed the seller's appeal and it dismissed the buyer's claim. So that, I think, is the latest decision that we've got in a line of decisions, all concerned with MAC provisions, material adverse change clauses. And I think a reason for that is because the COVID-19 pandemic saw lots of businesses suffer in unanticipated ways. And there has been really a bit of a spate of cases since 2020 with acquirers of those businesses attempting to rely on MAC provisions in order to recover their losses. So again, I think this latest decision by the Court of Appeal gives us a bit of helpful clarification on the approach that the court and indeed the parties should take when assessing whether or not there has actually been a breach of the relevant MAC warranty. So identifying what the correct metric is, identifying when you compare it, the dates, in order to work out if there has been an adverse change, and comparing the same thing at the two different dates. Okay, then finally, last one today. So this is a decision that I thought I'd mention where a loan agreement between a lender and a football club was held to have been novated to the club's majority shareholder, meaning that the shareholder and not the club was liable for the outstanding balance of the loan. So I said that the loan agreement had been novated. So what does that mean? What's a novation? So novation of a contract takes place where the relevant parties agree that an existing contract basically is replaced by a new one. So typically it occurs where you've got a contract between A and B, and that contract is replaced by a contract between A and C, with C stepping into B's shoes and assuming B's rights and obligations under that original contract. So remember, one of the elements that you have to form a contract is that there has to be consideration moving between the parties. So when you novate a contract, that consideration is provided by the discharge of the old contract. So specifically by A agreeing to release B, by B providing C as a replacement, and C agreeing to be bound by A. So the consideration sort of moves round in a circle, if you like. So one of the things that's you need for a novation of a contract is the agreement of all the parties. All three parties involved have to agree. And that agreement, consent, could be provided expressly, but it can also be inferred by the conduct of the parties. And it doesn't have to be in writing. And whether or not that agreement to the novation of the contract has been provided is going to be a question of fact. So the facts in this case were that a lender had made a loan of £350,000 to Oldham Athletic Football Club. And the loan was secured by a debenture granted by the club in favour of the lender. So the club's chair, who was also the majority shareholder, began negotiations for the sale of the club, and that involved discussions about the satisfaction of the debt owed by the club to the lender. Now, a key factor to be aware of here is that the lender and the chair had what the judge called was a very close connection. So, as part of all the sale negotiations, a letter was written from the lender to the chair that stated that the lender had made an agreement with the chair and that on completion of the sale of the club, the debenture with the lender will be satisfied personally by the chair. So we've got that letter between the lender and the chair talking about the loan and the debenture being satisfied personally by the chair. So subsequently, the lender sought repayment of the outstanding balance of the loan from the club. And the club argued that actually the loan agreement between the lender and the club had been novated to the chair, as evidenced by that letter. So the club argued that it had been released from its obligation to repay the loan. It was no longer liable to the lender under the loan agreement because its liabilities had effectively been transferred to the chair who'd stepped into the shoes of the club as regards that loan. So the lender argued, well, no, that's not right. The agreement hadn't been novated, and the chair had just agreed to pay the club's liability on its behalf rather than to assume all of its obligations under the loan agreement. But the judge here agreed with the club, and the judge said, well, it's clear from the surrounding evidence that the potential sale of the club was in fact proceeding on the basis that the chair would satisfy the debt to the lender personally. And it was against that particular background that the letter between the lender and the chair had been written. And the agreement set out in that letter amounted to an express novation of the debt from the club to the chair. There was an express agreement that on completion of the sale of the club's liability was immediately discharged and the chair stepped in and assumed that liability. And that express agreement had been made by the chair in a dual capacity. Remember, the letter was just between the lender and the chair, but the court said, well, when the chair was writing that letter, actually, the chair was acting both personally and also on behalf of the club. So there was a tripartite agreement between the original contracting parties, the lender and the club, and the new contracting party, the chair, which had been supported by consideration in the form of the chair's personal assumption of liability for the debt. So the loan agreement had been validly novated, and therefore the judge dismissed the lender's claim against the club. So when parties are wanting to transfer a contract, they're usually faced with a choice. They can either assign their rights under the contract or else they can novate it entirely. And the requirement for the other contracting party to consent to any novation means that actually it's pretty rarely used in practice because it gives that other party the opportunity perhaps to renegotiate the contract on more favourable terms in return for giving their consent to the novation. So I think this case, as usual, is a useful reminder both of the requirements for a novation and also, and I'm a lawyer, so I'm bound to say this, the advantages of ensuring that the parties' intentions are always accurately recorded in writing. It's a classic lawyer refrain, isn't it? Get it in writing. So there we go. I hope you've found that interesting, some background on some cases, and like I say, lots of new changes coming in 2024 for companies that you need to get up to speed with. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.